Yes, Mrs.
Thank you, Chair. Chair, we'll now begin with Mr. Adams' statement. What I propose, Chair, you'll see that it's a 64-page document, and if we were to go through the entire document, I don't think we'll finish in this week to finish on the 64 pages. I had a discussion with Mr. Adams as to how we'll deal with it, and he doesn't put anything in any particular sequence. So I suggested to him that I would go to the relevant topics because I think everything from page 1 to page 131 is probably irrelevant, most of it irrelevant for purposes of our terms of reference. The remaining 30 pages may have some relevance, and we'll obviously seek a lot of clarity from Mr. Adams there because he's very thin on dates and detail insofar as his involvement is concerned on these topics, but there are topics that are relevant. I have said to Mr. Adams, I don't want to restrict him from what he wants to say, but it must be within our terms of reference. It must be relevant to what we are dealing with. And to the extent that he makes allegations where he doesn't have the evidence to back it up in these proceedings, then we really shouldn't deal with it unless he invites us to then interrogate him on the merits of whether he does have the evidence or not. He's agreed that he will be guided by me insofar as the flow is concerned, so chronologically, but he will give his evidence rather than read the statement, he will give his evidence in his own words. I think that will go quicker, Chair, insofar as that is concerned. If it isn't, then we will ask him to read, but trust me, I've engaged with him. If he reads, he's still going to elaborate. So I'm trying to take the lesser of the two evils.
Maybe let's start and see how it goes.
So, Chair, you'll see that his personal background appears on page 10. And I think that is the place where he should probably start. So if he chooses to read, he may do so. But from my engagement with him, it seems like it's easier if he just summarizes. But we'll be guided by Mr. Adams for the time being, and then if we feel that it's not working out, we can then give some guidance. So it's on page 10 of your statement, Mr. Adams. It's personal background. Do you have it? Do you have it?
I have it.
Okay. You may proceed.
Thank you, Advocate, Commissioners. My personal background: I was born and raised in the Cape Flats in the Western Cape, where I spent the overwhelming majority of my life living, working and engaging with the communities that form the subject of much of the evidence before this Commission. I am by occupation a construction worker and a small business owner. Before entering public life, I operated a business that employed members from my local community. My involvement in community affairs developed through my day-to-day interaction with residents who were affected by poverty, violent crime, gang activity, and what I perceive to be failures by public institutions to respond effectively to those challenges. My early life was not without hardship. Like many young people growing up on the Cape Flats during the period, I experienced circumstances that exposed me to criminality, gangsterism, and substance abuse. Through the support of my family and my own determination, I was able to overcome those challenges, establish a lawful livelihood, and devote my efforts to community service. I mention these matters not to seek sympathy, but because they explain my understanding of the social conditions that continue to affect many communities in the Cape Flats, and that is why I became actively involved in public affairs. My involvement in civic activities arose from concerns regarding the socio-economic conditions experienced by communities on the Cape Flats, particularly the impact of violent crime, gang activity, and corruption, and what I perceive to be failures of public administration. Those concerns ultimately led to my participation in various community initiatives aimed at promoting accountability within government and law enforcement institutions. I was one of the founding members of the civic movement known as Gatful Capetonian. The movement was established to advocate on behalf of communities that believed themselves to be disadvantaged in matters relating to public administration, service delivery, employment, and policing. Through that work, I became involved in engaging with government departments, oversight institutions, law enforcement agency, and elected representatives concerning matters of public accountability. my subsequent election to public office, first as a councillor and later as a member of parliament, substantially expanded my responsibilities and access to information concerning the functioning of state institutions. Those offices also impose upon me statutory and constitutional responsibility to exercise oversight over the executive and organs of state, to raise matters of public concern and to report allegations of maladministration, corruption and unlawful conduct where appropriate. Over time, my public responsibility brought me into contact with numerous complaints relating to policing, organized crime, firearms control, procurement, intelligence structures, and alleged political interference in law enforcement. In many instances, I considered it my duty to refer to such matters as the appropriate investigated or oversight authorities rather than attempting to investigate them personally. These referrals, together with my interactions with the relevant institutions, form an important part of the evidence that follows. It is important to emphasize that this statement is not an attempt to recount every matter with which I have been involved during my public life. I've confined myself to those matters that are relevant to the Commission's terms of reference, or which provide the necessary factual context for understanding my subsequent interactions with SAPS, the PKTT, crime intelligence, oversight bodies, other institutions referred to in the statement, and my efforts to expose fraud and corruption within government structures. My evidence should therefore be understood against the background of an individual who has over many years consistently engaged with public institutions concerning allegations of corruption, maladministration, and failure of accountability. Whether those allegations are ultimately established is a matter for this Commission and other competent authorities other competent authorities it was meant to end with to decide, My purpose is to explain what I personally observed, what I reported, what responses I received, and how those events culminated in the matters now before this Commission.
Thank you, Mr. Adams. Then the next one, topic on page 13, public offices and anti-corruption work flows from there.
Thank you, Advocate. Commissioners. My election as a councillor in the City of Cape Town significantly expanded my responsibilities. In that capacity, I was required to exercise oversight over municipal administration, scrutinize procurement processes, consider complaints received from members of the public, and raise concerns regarding governance, financial management, and compliance with the law. During my tenure as councillor, I became involved in a number of matters concerning alleged procurement irregularities, public contracting, firearm management, municipal administration, and the conduct of public officials. In many instances, I did not seek to investigate those matters personally. Rather, I referred these complaints to SAPS, specialized investigative units, or other competent oversight bodies for investigation and determination. I subsequently became a member of Parliament. In that capacity, my constitutional responsibility included the oversight of executive and organs of state, participation in parliamentary committees, engagement with law enforcement institutions, and consideration of matters affecting public administration and national governance. My parliamentary responsibility serving on the Police Portfolio Committee brought me into regular contact with senior officials within the SAPS, the Civilian Secretariat for Police Services, the Independent Police Investigator Directorate, the Inspector General of Intelligence, and the National Prosecuting Authority, and other institutions responsible for policing, intelligence, and accountability. As part of my parliamentary functions, I receive complaints, documentation, and information from members of the public, whistleblowers, public officials, and other interested persons. I just wish to pause, Commissioners. It should say, as part of my parliamentary functions and my duties as a councillor at the time. Sorry for that. I regarded it as my responsibility to distinguish, as far as reasonably possible, between allegations capable of immediate verification and allegations required investigation by the competent authorities. Where I consider there to have been sufficient basis for concern, I refer the matters to the relevant investigating body or oversight body, rather than to seek to determine the merits myself. Over time, a number of complaints that I have referred related directly or indirectly to matters concerning organized crime, policing, intelligence structures, the PKTT, crime intelligence, alleged political interference in law enforcement, and the integrity of criminal investigations. It is those interactions and the responses I've received from relevant institutions that are principally relevant to the work of this Commission. I emphasize that my evidence before this Commission is not founded upon political affiliation or ideological disagreement with any person or institution. Nor do I ask the Commission to accept allegations merely because I have reported them. My evidence is founded upon personal involvement in making complaints, engaging with state institutions, receiving official responses, obtaining documentation, and participating in oversight processes over a number of years. Throughout my public career, I have consistently adopted the approach that allegations of corruption or unlawful conduct should, wherever possible, be referred to the institutions established by law to investigate them. The matters described in the following sections of this statement should therefore be understood against the background of my long-standing engagement with the issues of public accountability and my official interactions with institutions whose conduct now falls in whole or part within this Commission's mandate.
And then, Mr. Adams, if you can go to page 3 of your statement, where the heading is Statement to the Commission Regarding My Activism.
I now understand what you say about the
flow.
The flow. Sorry, Advocate. My statement to the Commission regarding my activism. I respectfully submit that this Commission is one of the most consequential commissions in the history of this country. Its recommendations may reverberate long after we are no longer here and may have significant consequences for law enforcement and the manner in which South Africans engage with law enforcement institutions. I was extremely fearful and concerned about the possible effect of this Commission on future whistleblowers and their willingness to report maladministration, corruption, and malfeasance. I now believe that some of those concerns have been misplaced. I recognize how necessary this Commission has been for this country and how important it is that individuals who were previously regarded as untouchable are now being held to account. Commissioners, we are in trouble. South Africa is in trouble and our communities are in trouble with the absence of effective and properly functioning law enforcement institutions. To illustrate the nature of the challenge, I wish to provide what I understand to be the prevailing perceptions and criminal challenges in each province. KZN is associated with hitmen, protection rackets, political killings, and related organized criminal activity. The Eastern Cape is associated with extortion, kidnapping, political patronage, taxi violence, and related criminality. Limpopo is associated with vehicle theft, illegal migration, illegal mining, and related criminal activity. The Free State is associated with cross-border livestock theft and tender-related criminality. The Western Cape is associated with gangsterism and violent crime. Gauteng is associated with various forms of organized criminal activity, including construction, mining, water, taxi, cash in transfer, and tender-related crime. The Northern Cape is associated with more sophisticated forms of criminal activity, including political gangsterism, tender-related criminality, and political patronage. Mkhwanazi is associated with coal mining-related criminal activity and tender-related criminal activity. The Northwest is associated with tender-related criminality and political patronage. A common denominator across these provinces is the political patronage system upon which, in my view, criminal networks rely. This remains a hidden hand in certain tender processes and may be connected to the killing and intimidation of whistleblowers. South Africa experiences thousands of violent protests every year by people demanding basic services. These protests have become increasingly violent. I was once asked by a foreigner, it was a white foreigner, just for the record, why people in South Africa burn libraries, schools, and universities when those are the very institutions needed to prepare communities for the future. My response to him was that many people are losing hope and do not foresee a future for themselves. Protest action has become for many the only time when they feel that they are seen and heard. In another country, the scale of these protests might be described as revolutionary. However, our government has, in my view, desensitized the public to the situation by referring to such incidents as service delivery protests, therefore making them appear normal. When certain Latin American countries, including El Salvador, Colombia, Nicaragua, and Panama, were described as narco states, drug dealers and gangsters exercised significant influence over the state. Politicians were allegedly bought or influenced to pursue the interests of cartels, including protecting them from prosecution and imprisonment. Haiti today is regarded as a failed state by many observers because the government has lost significant control over parts of the country and criminal gangs have taken control of territory and institutions. Commissioners, the elements that could render South Africa a criminal state are, in my view, increasingly documented through daily incidents and publicly reported activity. There remain institutions, including the judiciary, business organizations, and committed men and women within law enforcement who constitute an important bulwark against criminal elements overrunning the country. Every day we read reports concerning drug seizures, criminals allegedly controlling government institutions or tenders, politicians accused of bribery and corruption, and the weakening of the institutions that are supposed to constitute the last line of defense. I believe that the chaos currently experienced in this country is in some instances calculated and driven by various forces seeking to make the country ungovernable through an unmitigated wave of criminality. The community that I represent, a few weeks ago, experienced approximately 170 killings, which is worse than the situation in most war zones. Yet many of these people remain voiceless. The community I represent happens to be predominantly colored, and in my view, has been marginalized and disenfranchised by a failing law enforcement system. Commissioners, I was branded a racist and a colored nationalist when I formed the National Colored Congress. I reject that characterization. I come from an ANC family and have taken up many causes affecting vulnerable communities. I have, amongst other matters, taken up the case regarding the Sandisa Makaka matter because I believe that his mother and brother deserve answers concerning those responsible for his killing. There are many other cases from the Eastern Cape, Northern Cape, Gauteng and KwaZulu-Natal in respect of which I have been approached for assistance because communities believe that law enforcement agencies are not doing their jobs or have closed cases prematurely. When I inquire such matters, I'm often told that an investigation is ongoing and that I cannot interfere with it. Commissioners, I make no apology for trying to be a voice of my community. I make no apology for listening to my community, and I make no apology for exposing those who I believe are hiding behind a wall of silence. South Africa previously had a functioning criminal intelligence capability. In many communities, one can reasonably expect that somebody knows who committed which crime. I cannot say that with the same confidence today. In my view, crime intelligence deteriorated significantly during the period associated with former National Commissioner Jackie Salebi, and I believe that this deterioration was not accidental. I further believe that successive leadership structures within the SAPS have in some instances been compromised, suspended or incompetent, therefore serving political interests rather than the interests of effective law enforcement. Crime intelligence funds became, in my view, another slush fund or source of patronage and employment for friends and family, particularly during the period associated with Richard Ndluli, the former head of crime intelligence. The anti-gang unit in the Western Cape was allocated a budget of 7 million rand to fight gangsterism, whereas crime intelligence has a budget of 600 million rand. Commissioners, if one wishes to destroy a country's law enforcement capability, one only needs to destroy its ability to detect crime. This was evident during the unrest and looting in 2021, when crime intelligence, in my view, failed this country. This was also reflected by various reports concerning KwaZulu-Natal, which was headed at the time by Brigadier Khumalo, the current head of crime intelligence. Commissioners, I have paid a heavy personal price for my outspokenness and activism. The toll on my family has been immense, and the emotional trauma experienced by my children has affected their social and their school lives. My mother is elderly and sickly and had to witness some of the events, particularly my arrest. My salary and my privilege as a member of parliament have on occasions been withdrawn, affecting my responsibilities towards my family. I have regularly been threatened with arrest, even before appearing before this commission. I was warned that I would be arrested after my appearance. And to be frank, Commissioners, if that indeed is true, I don't care. My most recent arrest was, in my view, not merely intended to embarrass me, but also to silence me. I regarded it as a final warning to shut up and to know my place. But Commissioners, I can assure you that every time a mother, a child, a sister or aunt dies in my community, I will attempt to be their voice.
Then, Mr. Adams, the next topic, history of my interaction with the various matters discussed at the Madlanga Commission.
Thank you,
Page
Advocate.
7.
Thank you, Commissioners. This statement is not intended to constitute political commentary, argument or submissions on the ultimate issues that the Commission is required to determine. Those determinations fall exclusively within the Commission's mandate. My purpose is to place before this Commission the factual basis for my knowledge, my actions and the concerns that I have reported to various state institutions over a matter of years. For many years I have, in different capacities, reported allegations of corruption, maladministration, abuse of public office, and irregular conduct of organs of state, law enforcement agencies, and oversight bodies. Some of those complaints concern matters that overlap with the work of this Commission. Others provide necessary context to explain how I came to possess certain information, why I engaged with particular officials and institutions, and why I subsequently became involved in matters concerning the political task team, the PKTT, crime intelligence and related investigations. I recognize that many of the matters referred to in the statement remain the subject of ongoing investigations or pending legal proceedings. Nothing in the statement should be understood as expressing a concluded finding or criminal or civil liability against any individual. Where I refer to allegations, complaints or investigations, I do so because they form part of the factual chronology of evidence relevant to my evidence. I identify the status of those matters wherever I am able to do so. Where reference is made to annexures, those annexures are intended to corroborate or contextualize the facts set out in the statement. They include correspondence, official records, complaints, court documents, transcripts, recordings, and other contemporaneous material generated before or during the events described herein. Before addressing the factual matters that form the subject of this evidence, I consider it important to explain the approach I have adopted in presenting my evidence. Over a number of years, I have been an activist, a community leader, elected public representative, and a member of parliament. In those capacities, I have frequently spoken publicly on matters of corruption, organized crime, policing, governance, and public accountability. Those engagements have necessarily involved political debate, public advocacy, and expression of opinions concerning the matters of public importance. I appreciate that my role before this Commission is fundamentally different. I appear before the Commission as a witness and not as an advocate, commentator, or politician. I fully recognize that the Commission's function is to make findings based upon reliable evidence rather than rhetoric, opinion, or political persuasion. I have therefore sought to present my evidence in a manner that assists the Commission in discharging its mandate. Throughout the statement, I have endeavored to distinguish carefully between the facts that I personally witnessed, the actions that I took, the information communicated to me by identifiable individuals, which I identify as such, and opinions or concerns that are held relevant at the time where those opinions are necessary to explain my conduct or my actions. I do not ask the Commission to accept any allegation merely because I've made it. Where documentary or other corroborating evidence exists, I have identified. Where investigations remain pending, I have attempted to indicate the fact. Where I rely upon information obtained by others, I identify the source wherever I am able to do so. I also recognize that some of the matters referred to in the statement are or have been the subject of criminal investigations, civil litigation, or other processes. Where I express concerns, suspicions, or inferences, I do so because they explain why I have acted as I did, why I referred matters to the relevant authorities. I respectfully leave the determination of the facts and the drawing of ultimate conclusions to this Commission. I understand that my evidence, like that of every witness, must withstand scrutiny. I welcome that scrutiny. It is in that spirit and with due regard to the solemnity of these proceedings that I place the following evidence before this Commission.
Then the next topic is on page 15, but I propose that we not go through this topic. It's a duplication of what you deal with on page 18 onwards. So it's really a summary of the allegations. It's called Nature of Complaints Made Over the Years, and then you deal with it in detail from page 18. I would suggest that you just read paragraph 125 on page 18 into the record.
Thank you, Advocate, Commissioners. I respectfully submit there is not any single complaint that is significant. Rather, it is the cumulative pattern of interactions within state institutions, the responses that were provided to me, the investigations that followed, and the events that ultimately culminated in my own interactions with the PKTT, crime intelligence, and the matters now before this investigation. Before this Commission, excuse me.
Then the next topic, engagement with law enforcement agencies and oversight institutions.
Thank you, Advocate. Thank you, Commissioners. Throughout my public life, I have consistently adopted the view that allegations of criminal misconduct, corruption, or abuse of public office should be reported to the institutions established by law to investigate such matters. I have therefore sought wherever reasonably possible to utilize official reporting mechanisms rather than attempting to investigate or determine such matters myself. In the ordinary course of my work as a community activist, councillor, and later a member of parliament, I engaged with numerous law enforcement and oversight institutions. Those engagements arose from complaints made by members of the public, information that came into my possession, matters uncovered during oversight work, and documentary material that appeared to disclose possible criminal or unlawful conduct. On many occasions in the Parliamentary Committee, I sought to hold SAP's management accountable for various issues. The records of Parliament will reflect those engagements. For the purposes of this statement, and having regard for the limited time available to me, I will concentrate on issues that have subsequently come to the attention of the Commission. It has been deeply frustrated because, in my experience, the Portfolio Committee on which I serve sometimes fails to hold the SAP's management adequately accountable and instead permitted SAP's management to obfuscate, avoid questions, or rely upon standard answers such as "we cannot answer the question because it is under investigation," "we cannot answer the question because of security-related matters." On a previous occasion, I asked the National Commissioner how many members of his family worked in his office and whether those persons had gone through the proper appointed process. On the 18th of September 2024, I asked the National Commissioner, General Fani Masimola, to explain why Lieutenant General Dumisani Khumalo had been permitted to purchase a redundant cell phone grabber. No satisfactory response was provided. Please see Annexure FAA1. Page 8. In my view, the National Commissioner was permitted to avoid accounting to the Portfolio Committee concerning this matter. However, Brigadier Tiani Shlongweni has subsequently articulated reasons why, in his view, public funds have been wasted. This does not excuse what I believe to be a failure to account to the Portfolio Committee. Just for noting purposes, our commissioners are Brigadier Tiani Shlongweni was the CFO for the crime intelligence, what is called the slush fund. On 12 March 2025, I asked the National Commissioner about the top-level security clearances of senior SAPS officials. This included the issue of Lieutenant General Khumalo, whose first security clearance was allegedly fraudulently obtained. Please see Annexure FAA2. On 19th February 2025, I asked the National Commissioner to please provide to the Portfolio Committee the names of generals, including provincial heads, who lacked appropriate security clearance. Despite the National Commissioner's assurance that the information would be provided to the committee, to my knowledge, it never was. Please see Annexure FAA3. At the same meeting, on 19 February 2025, I asked the National Commissioner about the lack of media attention concerning case number 1/11/2024 relating to an incident in which more than 100 million rands worth of mandrax was allegedly found and no media statement was issued. Please see Annexure FAA3. General Abia responded that the clandestine laboratory was under investigation. The last known status of this case reflected firearms and made no mention of drugs. If I may just expand on this issue just a little bit and why I took this kind of personally. In KZN, on 19 February 2025, a Cape Town-based drug team uncovered a laboratory in KZN. They confiscated 100 million rands worth of drugs, mandrax. Now, in my view, the South African Police Services needs all the positive publicity it can get. This should have been a cause for celebration. They never reported it to the media, and certain people are saying that they were told not to speak about it. When I asked this question, I was told it was under investigation. The current status of that docket right now, speaks of firearms, no mention of drugs. Why I take this personally, Commissioners? It is a known fact that mandrax, it was the tablet that was used to enslave the Cape Flats. To this day, I would say 80% of mandrax sold in this country is sold right there where I live. Those drugs disappeared to be sold to our children. That is why I took that personally. I've also raised the issue of property purchase in Musgrave, KwaZulu-Natal. My concern was that crime intelligence did not have a mandate to procure properties outside the prescribed process, and that, to my knowledge, there had been no deviation or approval. I further raised concerns that the property price appeared to be significantly inflated. On 15 September 2025, I emailed the Inspector General, IGI, concerning the matter. A complaint had been lodged, and the IGI subsequently confirmed to me that he had completed his investigation and the final report had been provided to the Minister of Police. Please see Annexure FAA4. I requested of the IGI a copy of the report. The IGI, I think I was stupid with that, but anyway, the IGI informed me that it was not possible or lawful to provide such a copy to me. I accepted that. I subsequently contacted Minister Mkhwanazi, but did not receive a response. At that stage, I became concerned that there might be a cover-up of this report. Please say Annexure FAA5. Depending upon the nature of the complaint, I referred matters to SAP's specialized investigative units within SAPS, the WARCS, the NPA, IPID, the IGI, parliamentary committees, and other competent oversight bodies. My purpose in referring these matters is never to determine guilt or innocence. Rather, it is to ensure that allegations which appeared to disclose possible criminality or serious administration were investigated by the authorities entrusted by law with those responsibilities. Excuse me. In many instances, my involvement concluded once a complaint had been submitted together with the documentation that was available to me. In other matters, I was requested to provide further information, clarify aspects of the complaint, produce documents, identify witnesses, or cooperate with investigators. Commissioners, in some cases, I'm unable to receive the further information. For instance, the source may say to me, I'll get you that, and then he's unable to. Or the source may turn around and say, please don't mention my name. So in some cases, I do lay charges, and unfortunately nothing is able to happen. My level of involvement therefore vary depending upon the nature of complaint and the responsibility of the investigating authority. During these engagements, I became familiar with the manner in which different investigative and oversight institutions responded to complaints of corruption and organized crime. Some complaints were investigated promptly, others were referred between institutions, and some appeared to progress slowly or not at all. I do not suggest that every delay or outcome was improper. I merely record my observations because they form part of the factual background against which the matters now before this commission have developed. As the number of complaints increased over time, I observed that certain investigations begin to overlap. Matters involving organized crime, firearms, procurement irregularities, intelligence structures, and policing increasingly involved recurring institutions, officials, or investigative structures. It was through these recurring interactions that I became aware of issues relating to crime intelligence, the PKTT, and allegations of interference with criminal investigations. I wish to make it clear that I did not ask the Commission to infer wrongdoing merely because I lodged complaints or because investigations are initiated. The existence of a complaint is not proof that it is true. My evidence concerns the fact that complaints were made, the information upon which they are based, the responses I received from the relevant institutions, and the events that follows. In several instances, I retained copies of correspondence, acknowledgements of receipt, emails, affidavits, recordings, and other contemporaneous documents generated during my engagement with the relevant authorities. Some of those documents have been preserved, were available, and annexed to this statement, or will be made available to the Commission as we have it. They provide an objective record of many of the interactions described in the chapters that will follow. I again apologize for documents that I may have omitted. Such omissions were not deliberate, but have resulted from circumstances sometimes beyond my control. My engagement with these institutions was not confined to reporting complaints. In my capacity as a Member of Parliament, I also exercised parliamentary oversight by posing questions, participating in committee proceedings, scrutinizing reports, and engaging directly with senior officials concerning matters falling within their respective mandates, including in terms of Section 55.2 and 56 of the Constitution. These engagements frequently provide additional context for complaints that have already been referred through formal law enforcement channels. As a source of further information, I also conducted parliamentary oversight visits in accordance with the National Assembly Rule 201.6, where I received complaints regarding further investigation or oversight. In the chapters that follow, I deal with each of the principal engagements separately, identifying the chronology of events, the institutions involved, the documents relied upon, the responses received, and where applicable, the significance of those events to the Commission's term of reference.
Then, still on page 23, the next topic, complaints concerning crime intelligence. There are some complaints that are historic that don't really relate to the issues that you were asked to address. So at some point, I'm going to ask you to skip some paragraphs. But you can start with 169.
With respect, Advocate, if I may ask on this paragraph, if I may be allowed to read everything into the record?
Okay.
Thank you very much. My concerns concerning crime intelligence. Crime intelligence is at the heart of the fight against crime, and this is in my view, the pulse of policing in relation to crime prevention and detection. A malfunctioning crime intelligence unit has extremely far-reaching consequences for the fight against crime, as is evident from the current situation. In my view, crime intelligence in South Africa, particularly since 2000, has been used for various purposes, including political battles, patronage, and the maladministration of slush funds. I believe this was perfected during the period associated with Richard Mdluli. In my view, crime intelligence operated on a nepotistic basis involving jobs for friends and family, and at times functioned more like a glorified employment agency. I have attached an example of nepotism in Annexure FAA26. Numerous reports have previously been commissioned concerning crime intelligence and its weaknesses, but in my view, insufficient action was taken to eradicate the problems that have developed. Crime intelligence, in my view, requires a complete overhaul, together with a structured approach to the execution of its mandate. Unfortunately, it appears to me that Lieutenant General Khumalo has followed in the footsteps of the former leadership within crime intelligence. This chapter deals with my interactions with and concerns relating to crime intelligence and the associated intelligence structures within the subs. The matters described herein do not arise from a single event. Rather, they develop progressively over a period of time through complaints received by me, documentation that came into my possession, my engagement with oversight institutions, and my interactions with members of law enforcement. My interest in matters relating to crime intelligence arose in the course of performing my duties as a councillor and later as a member of parliament. During that period, I increasingly encountered allegations suggesting that intelligence structures were becoming relevant to complaints involving organized crime, policing, political interference, and the administration of criminal investigations. I regard crime intelligence as having been a festering open wound that has continued to attract undesirable and in some cases criminal activities since approximately the year 2000, although similar problems may have existed to a lesser extent even before then. In my view, successive heads of crime intelligence were selected in circumstances that gave rise to concerns regarding political influence and accountability. During this period, the crime intelligence budget also increased disproportionately compared with other internal policing units and divisions. In my view, crime intelligence was not always utilized primarily for intelligence gathering, but at times was used for personal gratification, patronage, and employment of friends and associates. At the outset, I did not possess sufficient information to determine whether all of these allegations were well-founded. My approach was therefore not to make public findings or conclusions, but to seek further information, preserve relevant documentation, and refer matters to the authorities responsible for investigating them. As additional information became available, I observed recurring references to officials within crime intelligence, the administration of intelligence resources, security clearances, intelligence oversight, and the interaction between intelligence structures and criminal investigations. It was these recurring themes, rather than any preconceived belief, that caused me to examine the matters more closely. Where I received documentary material that appeared to disclose possible irregularities, I sought to preserve that material in its original form and, where appropriate, refer it to the competent authorities. Where information was communicated to me by third parties, I attempted, wherever possible, to identify the source of that information and distinguish between verified facts, allegations requiring investigation, and matters that could not be independently confirmed. During the course of my parliamentary duties, I also engaged with senior officials and oversight institutions concerning matters relating to policing and intelligence. Those engagements, together with official correspondence and responses received from the relevant institutions, assisted me in understanding the statutory framework governing intelligence structures and the mechanisms established to ensure their accountability. Certain concerns that I raised were subsequently referred to or considered by oversight institutions, including the IGI, and other competent authorities. I do not suggest that the existence of such referrals establish the correctness of these allegations. I refer to them because they demonstrate that these matters were considered sufficiently serious to warrant investigation by institutions responsible for intelligence oversight. As my engagement with these matters continues, they increasingly intersected with issues concerning the PKTT, allegations of political interference in policing, the appointment and deployment of senior officials, security clearances processes, and the integrity of investigations falling within the Commission's terms of reference. The purpose of this chapter is not to invite the Commission to draw conclusions concerning crime intelligence as an institution or any individual official. Rather, it is to explain how my interactions with intelligence-related matters developed, the steps that I took to report my concerns through official channels, and the factual background against which the subsequent events described in this statement occurred. In the chapters that follow, I deal individually with the principal matters that inform my concerns regarding crime intelligence, including the information that came into my possession, the referrals that I made, the responses that I received, and the extent to which these matters are relevant to this Commission's inquiry. Where I express concerns or draw inferences, I identify the factual material upon which those concerns were based and distinguish them from matters falling within my direct or my personal knowledge. I respectfully emphasize that this Commission is not being asked to accept my concerns at face value. My evidence is directed at establishing the chronology of events, the information available to me, and the relevant times. The steps that I took in response to that information and the documentary record that supports those actions. The ultimate findings in relation to crime intelligence, its officials or any related institution remain matters exclusively for this Commission.
The next one is complaints concerning the political killings task team, and I'm sure you're going to tell me you want to read all of this as well.
I thought we agreed to play nice this morning, our advocate.
I am, believe me.
My complaints regarding the political killings task team. My engagement with matters concerning the PKTT did not arise from any personal animosity towards members or any political disagreement concerning its continued existence. My concern was the financial support the unit investigating a few dozen murders was receiving. There's just a correction that needs to be made here. The PKTT has a 100 million rand a year budget that does not include overtime.
So not 1 million?
Not 1 million, that's my mistake. This happened in haste, please excuse me. So the PKTT has a 100 million rand a year budget that does not include overtime. It is actively investigating 130 murder dockets over the last 36 months. This translates into a total spend of about 2.3 million rand per murder docket. In contrast, the AGU that operates in my community in that same period would have been combating approximately 8,000 murders on the Cape Flats, of which the majority of them are coloured children. The Cape Flats is an area that is roughly 10% the size of KZN. In comparison to the PKTT, the AGU receives 2,600 rand per murder docket. It makes no sense. I was also under the impression that when the President announced the establishment of the unit, it would have had an end date because the mandate of a task team in general is specific, and that this unit, the PKTT, was not intended to become one of the more permanent structures of the SAPS. I therefore became concerned when I subsequently learned that the PKT was operating in the Western Cape, the Eastern Cape, Gauteng, and elsewhere, as it is supposedly a KZN structure according to Lieutenant General Mkhwanazi. During the course of my public duties, I became aware of allegations concerning the matter in which certain investigations involving the PKTT had been conducted, including allegations relating to investigative independence, the exercise of police powers, and the interaction between the PKTT and other components of SAPS. I was approached by two persons who I understand to be labour lawyers from Century City in Cape Town. They indicated that they had been commissioned to act on behalf of a SAPS member in a labour dispute in which General Dumisani Khumalo was cited as a respondent. A meeting was requested, during which, this is between them and myself, during which they alleged that they had been abducted by members of the PKTT and unlawfully taken to the Northwestern Province. They indicated that they had instituted a multi-million rand claim against the SAPS. They claimed that they had referred the matter to the police committee and that Ian Cameron wrote back to them in September in 2025 stating that this was within the mandate of IPID, but they have heard nothing since. I am able to provide further details concerning the persons that I met, but I have not included their identities in the statement in order to protect their anonymity. Please see Annexure FAA6. I'm just thinking if you could not at a later stage flight that WhatsApp, because I don't think I scratched out a telephone number.
We will
Thank
do
you.
so.
My concerns intensified when information came to my attention, suggesting that I myself had become the subject or interest of members of the PKTT. At that stage, I had not been informed of the precise nature of the investigation involving me, nor had I been furnished with formal documentation explaining why the PKTT had become involved. Upon receiving further information that the PKTT was allegedly seeking my arrest, I did not avoid law enforcement authorities or seek to frustrate any investigation. On the contrary, I instructed my legal representation to engage with the relevant authorities and ascertain whether a warrant in fact had been issued, the nature of the allegations against me, and the jurisdiction within which those allegations arose. My intention throughout was to cooperate with any lawful process while ensuring that my constitutional rights were respected. Correspondence was accordingly addressed to senior officials within the SAP seeking clarity concerning the reported warrant and requesting engagement with my legal representatives. I expressly indicated that should a lawful warrant exist, I was prepared to present myself through appropriate legal processes rather than necessitating an operational arrest. Please see Annexure FAA7. The response that followed and the subsequent execution of the warrant are dealt with in greater detail later in the statement. My first concern was that when I am in Parliament or when I'm participating in parliamentary oversight processes, I am protected by parliamentary privilege. My presence there recognizes me as part of a constitutional institution. The events that subsequently unfolded, including the execution of my arrest, my transportation to KZN, the attempted seizure of my property, and the manner in which the investigation was conducted significantly heightened my concerns regarding the conduct of certain members of the PKTT. Those matters are not advanced as proof of institutional misconduct, but they confirmed, in my view, the execution of threats that had previously been made against me. They are described because they form part of my direct personal experience and are relevant to the issues that the Commission has been established to investigate. Upon receiving bail, I discussed with various police officers residing in the Western Cape. Upon receiving bail, I discussed my arrest with various police officers residing in the Western Cape. I was informed that the PKTT had allegedly not informed the Western Cape Provincial Commissioner at the time, Lieutenant General Patikile, or any of his subordinates of my impending arrest. Please see Annexure FAA8. It appeared to me that in terms of SAP's protocol, it would have been logical and cost-effective for an accused person to appear at the nearest lower court for determination of bail. This was denied to me. Instead, I was transported in the back of a police van with no protective covering. They literally took off the side covering in a Schedule 6 storm that lasted approximately 8 hours. Commissioners, just so you understand what I'm saying. When I was arrested in Pelican Park, I was told that they would take me to Grassy Park Police Station, which is up the road. I asked if I could only fetch a pair of socks and something to put on because I had a very thin sweater on. They escorted to my parliamentary house. I took socks, I took shoes, and I put on a slight hoodie because the weather was very overcast, anticipating that they're going to take me to Grassy Park. The medication that I take every day, I thought my wife would bring it to Grassy Park. I was taken to KZN. It was the worst storm Cape Town had experienced in probably 10 years. I was swimming in the back of that van, and I'm waiting for my lawyer who represented me at my first appearing to send the photo that they took of me in the police cell so you can see how swollen my shoulder was. I just want to give you context of my arrest. The trip to Cape Town to KZN took approximately, I'm saying 30 hours, but I think it was less. I think I'm exaggerating there. The brigadier, Mate, told the media that I was transported this way because it was cost effective. But I have parliamentary flights available to me that I could have made use of. And Brigadier Mate does not tell the media that 4 vehicles took me to KZN. In terms of diesel alone, I mean, I'm not a drug dealer. I'm not a shooter. It was unnecessary for that. It was excessive. It was literally used to create a narrative. The events that occurred on 5 May 2026 are detailed in the criminal case that I intend to pursue and which is due to be addressed when I appear in the Pinetown Magistrate Court on August 2026. During this period, I became aware of matters concerning the relationship between the PKTT, crime intelligence, senior police management, and other investigative structures.
Mr. Adams, so during which period? You say during this period. What period?
From the time of my arrest to present, sorry.
Okay.
Those matters reinforce my belief that concerns regarding accountability, oversight, and the proper exercise of investigative powers warranted careful and independent examination by the competent authorities. In my view, independence within policing structures is being compromised by Lieutenant General Khumalo serving as both the head of crime intelligence and the head of the PKTT. Likewise, Lieutenant General Mkhwanazi is the head of organized crime and the Provincial Commissioner of KwaZulu-Natal. In my view, the duality of these roles compromises investigative independence and creates an opportunity for abuse of process. I regard my own arrest as an example of what I believe may constitute such an abuse of power. It is my understanding that special task teams previously reported directly to the provincial commissioners. It is important that I make my position clear. I do not contend that every member of the PKTT has acted improperly or that every investigation undertaken by the unit was unlawful. Nor do I suggest that the mere fact that I became the subject of an investigation establishes a proper motive, an improper motive. My concerns relate to identifiable justification, action and events which, in my respectful view, justify scrutiny by independent oversight bodies that now fall within the factual matrix before this commission. I have, wherever possible, preserved the documentary record relating to my engagement with the PKTT. That record includes correspondence between my legal representatives and SAPS, court documents, official communications, email, and other material generated before, during, or after my arrest. These documents provide an objective chronology of which my oral evidence may be tested. The purpose of the chapters that follow is therefore not to invite the Commission to draw broad conclusions regarding the PKTT as an institution. Rather, I tend to deal sequentially with the principal events that inform my concerns, including the information that I received, the steps that I took, the responses I followed, my arrest and detention, and the subsequent developments that are relevant to the Commission's terms of reference. I respectfully invite the Commission to assess these events not in isolation, but against the documentary record, the evidence of other witnesses, and the objective chronology that emerges from the materials placed before it. My evidence is directed at assisting the Commission to establish that chronology and to understand the basis upon which I inform my concerns that I subsequently reported through lawful and official channels. I respectfully request that the Commission consider the validity and circumstances of my arrest, having regard to the documentary evidence before it, including evidence which is objective rather than subjective. I submit that such evidence may assist the Commission in determining whether there was operational bias or predetermined intention to punish me by members of the PKTT in relation to my criminal case concerning alleged misconduct against persons associated with Lieutenant General Mkhwanazi.
Okay, the next topic, interaction with the Inspector General of Intelligence.
Thank you, Advocate, Commissioners. I was contacted by the Office of the IGI in November of 2024 during my efforts to have my criminal cases investigated by SAPS.
Can I just ask you who contacted you from the office?
It was a woman, but I do not remember her name, Advocate. I sat with this. I actually can't tell you what her name is, but it was a female.
Okay. Was it Governor?
No, it was not. I only met Advocate Governor at a later stage. It was not her. At least I don't think it was her. Before she comes in and said it was her, I doubt it was her.
Okay, continue. It was just clarification.
An inquiry was made about the cases that I had lodged and asked whether I would attend the offices in Pretoria because the department had an interest in the cases that I had lodged with the SAPS. During the same week, I visited the IGI's office where I spent some time explaining the nature of my concerns.
Can I ask you, who did you meet with at the IGI's office?
I was met at the gate by a young lady, again, whose name I don't remember. She took me to a room where the IGI was sitting having coffee. He told me that Advocate Governor would be there in a few minutes. Asked me to sit down. And he asked me a little bit of what I had. And then Advocate Governor came, he handed me over to Advocate Governor and he left.
So you met with Advocate Governor and
And the IGI,
and the IGI.
Mr. Faisal? Yeah. I've just,
And that was during the same week, meaning the same week as the week when they contacted you?
yes, Advocate.
Okay.
The IGI referred me to Advocate Governor, who I understood to be a member of his staff. I handed the relevant information to her and subsequently returned to Cape Town. A few months later, on 28 March, I emailed the IGI regarding the status of the investigation as previously referred to in Annexure FAA4. The IGI advised me that his report had been completed and provided to the Minister of Police at the time, Minister Mkhwanazi. Having regard to the nature of the allegation and the specialized oversight functions entrusted to the IGI, I considered it both appropriate and necessary to refer relevant information to that office rather than attempting to investigate related matters myself. My engagement with the IGI was undertaken in good faith and through lawful channels. My purpose was not to obtain political advantage or to influence any investigation. Rather, it was to place information before the statutory authority entrusted by Parliament with oversight of the intelligence services and to permit that office to determine whether further investigation was warranted. So just so that you understand where I was at that time. I, at the time, did not know that the IGI had oversight over crime intelligence. I thought that was the mandate of SAPS. So that was explained to me on the day.
And can I just ask you, in that November 2024, did you engage with anyone else from the IGI?
No, ma'am. It was Ms. Governor and Mr. Faisal. I've never spoken to anyone else from the IGI.
Okay, continue.
In support of my referral, I provided such information and documentation as was then available to me. I regard the IGI as the appropriate institution to assist allegations relating to intelligence structures because that office possesses investigative powers, access to classified information as authorized by law, and statutory responsibility that I, as a Member of Parliament, do not possess. My role was confined to reporting information, providing documentation where available, and cooperating with oversight processes. During the course of my investigation with the IGI, of my engagement with the IGI, I became aware that aspects of the matters referred to me were receiving official consideration. I regarded that development as confirmation that the issues I had raised warranted examination by a competent oversight authority. I do not, however, suggest that the existence of such engagement constitutes proof of the allegations that were subject to my referral. Those matters remain to be determined of the evidence available to the relevant authorities. Certain developments concerning the work of the IGI subsequently became matters of public record, including litigation and official proceedings relating to the independence of the office and allegations of interference with its investigations. I refer to those matters only insofar as they provide context for my own interactions with the Office of the IGI and the chronology of events described in the statement. I do not rely upon those proceedings as proof of the allegations that I reported.
Then the next topic, various allegations made about me by witnesses at the Madlanga Commission. The first is Lieutenant General Mkhwanazi.
Thank you, Advocate. Thank you, Commissioners. Prior to the events described below and the press conference held by Lieutenant General Mkhwanazi, I have never had a personal or social or professional relationship with him. Prior to these events, I admired him and I held him in high regard. When I watched the press conference held by Lieutenant General Mkhwanazi on 6 July 2025, at which he made various claims to the South African public concerning alleged collusion and criminality within the SAPS, reference was made to a politician who he claimed was interfering in SAPS affairs. Following the press conference, my phone was inundated with messages from people asking me whether this guy was planning a coup. The manner in which the press conference appeared to me was highly militaristic, including the presence of masked armed men standing behind him. It reminded me of the manner in which Captain Ibrahim Traoré of Burkina Faso appeared during the period surrounding his coup. I was extremely concerned that a provincial commissioner had made allegations of this nature. rather than the National Commissioner, particularly having regard to the SAP's National Instruction and policy relating to the media, including SAP's National Instruction 5 of 2017, entitled Media Communication in the South African Police Services. At the ad hoc committee, the National Commissioner confirmed that Lieutenant General Mkhwanazi had indeed approached him and that he had given him permission to raise the issue and hold the press conference. The National Commissioner indicated, however, that Lieutenant General Mkhwanazi had exceeded the permission in respect of what he said and that an inquiry was still intended. I am not aware of any inquiry to this day. My concern was extremely serious and my mind turned to the possibility of a potential coup. I then considered which institution possessed the capability and the capacity to execute such an action. The police, as a large and geographically distributed force present in all 9 provinces, stands out to me, particularly in services where the South African Defence Force appears comparatively weak. I also considered the relationships between various provincial commissioners. In my view, Lieutenant General Mkhwanazi stood out, except in Gauteng, where tensions appear to exist between the provinces. Lieutenant General Mkhwanazi, Lieutenant General Khumalo, according to information that came to my attention, referred to Gauteng SAPS members as criminals. As a matter of fact, let me just clarify that. Lieutenant General Khumalo had said on TV that 90% of Gauteng SAPS is corrupt, which I find unbelievable. I also raised the issue of why General Mkhwanazi had been appointed for only 3 months by the late police minister, as well as various allegations concerning the discipline of ANC-deployed cadres within the police. If I may, Commissioner, I know I'm sometimes hard to listen to. I was sitting in the ad hoc committee when General Mkhwanazi makes the statement, and I found it rather, I'm looking for the right word. I found it provocative because the MK cadres who were referred to SAPS, to my knowledge, were people like General Jeremy Vieri, General Andre Lincoln, General Theo. These were men that sacrificed their prime to fight for me. And what I have is an apartheid commission police officer criticizing them. I felt it was untasteful. That just didn't sit well for me. Where am I now? All of these issues raised alarm bells for me concerning General Mkhwanazi and his reasons for calling the press conference. In subsequent interviews and during his appearances before both the Madlanga and the ad hoc committee, he clarified that I was one of the politicians to who he had been referring to. Lieutenant General Mkhwanazi testified under oath at the Madlanga Commission and the Parliamentary Ad hoc Committee in late 2025 and early 2026, respectively. He made various allegations against me, to which I respond below. I also wish to point out that General Mkhwanazi did not, to my knowledge, possess the required security clearance at the relevant time. Yet he referred to various classified matters and individuals. May I proceed?
Yes, subtopic is allegation is unauthorized access to intelligence information. These are allegations made by General Mkhwanazi against you.
Thank you, Advocate, and thank you, Commissioners. I've actually expanded a little bit here, and I don't know if that was proper, but if you'll allow me to read it. Allegation, unauthorized access to intelligence of information. Lieutenant General Mkhwanazi alleged that I had obtained access to intelligence information and that I had handled it recklessly. This allegation is denied. I have not obtained any documents illegally. As a political party, we have been approached by numerous whistleblowers who have provided information to us both in person and through other means concerning SAPS and other state institutions. When I received the relevant information, I opened a case with SAPS, as I have done previously when information was brought to us as NCC. After reviewing the information, I considered that if the documents were authentic, the allegations would warrant investigation. I therefore proceeded to open a criminal case with the SAPS so the matter could be investigated. Out of all these concerns, Lieutenant General Mkhwanazi appears unconcerned that my case dockets were intercepted by Lieutenant General Peter Jacobs and hid in a safe in Pretoria. Lieutenant General Jacobs has never been called to account or charged by any law enforcement agency as far as I know. Please see Annexure F8824. If I may just expand on that one little paragraph. I did find it shocking, Commissioner, that SAP's Grand Central is right across the road from Parliament. It's literally a 3-minute walk. So when I received these documents, I took it to the nearest police station. I mean, this is me thinking I'm doing the right thing. The general is upset with the fact that I went to the police station, but he did not once mention the fact that Peter Jacobs unlawfully took those documents and that it was found in his safe in Pretoria a month later. Now, I wouldn't have known of that until it came out here. But I'm saying that the general, to this day, has not asked Peter Jacobs, why would you do that, general? You know, the problem we have on the Cape Flats, murder dockets get missing daily. This is a serious thing to me. Murder dockets, rape dockets, drug dealing dockets, they disappear because of police corruption. Now, if this is not the epitome of police corruption, then someone needs to tell me that so that I understand. The allegation, classified crime intelligence information. Lieutenant General Mkhwanazi alleged that I obtained classified crime intelligence information despite not being a member of the Joint Standing Committee on Intelligence. This allegation is denied. During the last week of October, I found a document in my parliamentary office in Cape Town. I presumed that the docket had been pushed under my door because I found it on the floor when I opened the door. Receiving documents in Parliament in parliamentary offices while members are absent is not unusual. Parliamentary administration may place documents under the doors of members. It is also common for members of the public to provide information to members of Parliament concerning various matters, particularly when they are frustrated by government departments' failures to respond to allegations of fraud and corruption. Some persons and organizations have approached the NCC in person. Others provide information to us through third parties, while others have simply dropped documents at our offices. After reading the document, I discussed the matter with my fellow NCC parliamentarian, Honourable Sakina Frenchman. We considered that the information should be passed to SAPS for investigation. I did not meet the person who provided the information and did not unlawfully obtain any information from the JSCI. The assertion by Lieutenant General Mkhwanazi that I should have passed the information to the JSCI is, in my view, it's misleading. And it is misleading because at that time there was no JSCI. That body was not constituted. At the time I opened the criminal case with the SAPS, I did not understand the JSCI to have jurisdiction over the criminal complaint that I was reporting. Also, no JSCI was constituted at the time. I am also not the only member of Parliament to have received documents in this manner. In the past, members of Parliament, including Honourable Patricia de Lille, have publicly stated that documents related to significant matters were delivered or placed under their office doors. It has now become, and I don't know if it's true, but the media is running a story that Honourable Darlene James also received information. I'm not saying that she did, but I said from the word go, Commissioner, it wouldn't make sense that someone would only give this information to me. It just wouldn't make sense. The allegation of State Capture 2.0. Lieutenant General Mkhwanazi alleged that I was involved in State Capture 2.0, whereby high-ranking officials and members of Parliament were being used to dismantle effective police units. This allegation is categorically denied. I respectfully submit that this Commission should require evidence to substantiate such serious and potentially defamatory allegations. I also just wish to add, I find it funny, Commissioners, that the man who was the National Commissioner at the time of State Capture and didn't say a word about it is now accusing me of being part of State Capture 2.0. It's hilarious. Allegations concerning Paulsmoor Prison. Lieutenant General Mkhwanazi said I should go to Paulsmoor Prison and sit there for a while so that I can learn something. I regard such a statement by a high-ranking police officer as deeply concerning. In my view, allowing a senior police officer to make statements of this nature is indicative of a failure by SAPS to hold its members to the required standards. I have made a statement that is deemed to be non-parliamentary and I get docked my salary. This man runs amok. He's a law unto himself. In my view, Lieutenant General Mkhwanazi's conduct demonstrates an attitude that he's above the rule of law and that he may make statements without appropriate restraint or accountability. I further contend that such conduct is inconsistent with the standards of discipline expected from a senior police officer. Allegations concerning my complaint to SAPS. Lieutenant General Mkhwanazi advised the Commission that the complaints which I filed on SAPS were based on information that lacks substantive criminal elements and that I had encroached upon internal police procedures over which I had no jurisdiction. This allegation is denied. Furthermore, Lieutenant General Mkhwanazi, to comment upon the contents of my complaints, he must have, in my view, had case of my criminal case dockets. He is, after all, the Provincial Commissioner of KwaZulu-Natal. I therefore ask how he had sight of case dockets in Cape Town and Gauteng, particularly given the concern raised about his own security clearance. This, in my view, illustrates a broader problem within the SAPS, where case information may be circulated with what I regard as an informal SAPS network or cabal with the effect of protecting those who themselves are accused of corruption. I just want to, before I move on to the next the next heading, Commissioners, and just ask you to understand, as someone who loses people daily, and when I tell you I lose people daily, I know dozens of families in every ward in the Cape Flats. When they post tonight that 15 people have been shot, I can guarantee you, I will know 2, 3, or 4 of them. Sometimes in passing, sometimes personally. Sometimes they are related to people that I know. So this type of behavior is unacceptable to me. When I find out that my provincial commissioner at the time, Lieutenant General Patikile, doesn't have a police clearance, it makes my blood boil. Because this man is sitting with intelligence information. He's using this information to sign off on budgets. He's giving operational instructions without the recognized clearance. It is in actual fact as if, Commissioner Khumalo, to use you as an example, not because you look the part. If you were a taxi driver and you didn't have PDP, that is what they've reduced the South African Police Service to. Now when you find out that out of the 9 provincial commissioners, only 2 have clearance, we understand why our children are dying like flies. Where was I? Allegations concerning classified... I was just teasing our advocate. Allegations concerning classified reports and the Secret Service account. Lieutenant General Mkhwanazi alleges that I received and I shared classified reports concerning internal SAPS vetting and the Secret Service account or slush fund, therefore compromising the KwaZulu-Natal political killings task team by exposing its operational funding and vehicle procurement. This allegation is denied. The information available to me indicated an alleged contravention of the Public Finance Management Act. If Lieutenant General Mkhwanazi is aware that I possess classified documents and believes that I acted unlawfully, he should have laid a charge at the nearest police station rather than threaten me. Instead, he elects to make public statements against me in the South African media concerning my alleged exposure of corruption, which of his own version he's known about for many years. This is a serious question to me. Everything is known about Chairperson. General Mkhwanazi never opened a single case. He indicated that I was being used. That may be his belief, and it in fact may be true, but it does not make the information that I brought to the relevant authorities irrelevant. Allegations that I am a conduit for a criminal cartel. Lieutenant General Mkhwanazi alleges that I am a conduit for criminal cartel seeking to weaken the South African Police Service. This allegation is denied and it is false. It has been made without substantiation. In my view, in the same manner, several other statements made by Lieutenant General Mkhwanazi, which have not been properly tested. And I really hope this commission is going to. I thought the PKTT was coming again. On the contrary, Lieutenant General Mkhwanazi publicly claimed that fellow generals were innocent, as if he possessed authority equivalent to that of a judicial officer. You see, Judge, when I tell you my evidence is not a conviction, that's because it's not a conviction, it's an allegation. For a general to come on TV and say this one is innocent, he's told the courts that we no longer need them. The investigators will decide. I find this particularly concerning because a magistrate, that statement of Mkhwanazi, that General Mkhwanazi, that they were innocent, it's concerning to me because a sober magistrate had, on the available evidence, found sufficient grounds to issue an arrest warrant. General Mkhwanazi, instead of making allegations against me, should perhaps explain to this commission if he is in actual fact the conduit for Mr. Timmy Marimutu, a known criminal who he is alleged to have a close relationship with. There are in fact allegations that General Mkhwanazi has interfered in the arrest of Mr. Marimutu, and it is a fact that Mr. Marimutu's wife has worked in crime intelligence as a police colonel, her first job in the province of KZN, where General Mkhwanazi is the provincial commissioner. Now, Chairperson, I assume that Mrs. Marimutu worked in crime intelligence under the tutelage of General Dumasani Khumalo. If crime intelligence cannot understand that a wife of a convicted criminal, an alleged drug dealer, is heading a department, then I am concerned, Chief. Response to paragraph 3, 1.3 of the rules of notice. Am I jumping the gun? I'm sorry, my control issues are taking over here.
No, that's fine. This is the response to the Rule 3 notice. Do you want to proceed with that?
Yeah, this is the part where I get in trouble, but yeah. I also, just before I move on to the Lieutenant General Mkhwanazi does allege that I am a conduit for a criminal cartel and that I am trying to weaken the SAPS. The SAPS has weakened the SAPS, Chief, not me. My response to paragraph 1.3 on the Rule 3 notice. In paragraph 1.3
It is really a repeat of what you've said.
Then I will not insist to read it, Advocate.
Can you then go to the next topic on page 43, IDAC?
Thank you, Advocate. Thank you, Commissioners. Just give me 1 second, please. My phones are off. I am extremely concerned and shocked about allegations of impropriety at the Independent Directorate Against Corruption concerning the investigation and concerning the investigating director herself. If these allegations are proven true, I submit that the persons responsible should face the full force of the law. The performance and attitude of IDAC members during the testimony before the Commission was extremely disconcerting and leaves much to be desired for an organization of such importance. The blame shifting, the innuendo, backstabbing conduct that I regard as treacherous and personal grievances revealed point, to my view, to a seriously dysfunctional organization. In my view, the conduct disclosed during the testimony raises serious questions about whether some members of IDAC are capable of fulfilling their responsibilities. I respectfully hope that the Commission will make serious recommendations concerning those members whose conduct warrants such consideration.
Then response to IDAC witnesses on page 44.
Thank you, Advocate. Thank you, Commissioners. I am not able to comment fully on the various statements made by Head of IDAC, Advocate Johnson, because the matter is under investigation and I do not wish to prejudice the criminal case that is being investigated.
Which case were you referring to?
I laid a criminal case. I laid a criminal case against IDAC, Advocate. I've got the case number on my phone. Can I give it to you during the lunch break?
No, that's fine. You say IDAC, IDAC itself, the institution.
I laid a case against the members of IDAC.
Which members?
Dylan Perumal, Brian Padiachi, but I did request that the institution itself, but those were the two names, because at the time when I laid the case, I hadn't really heard Andrea Johnson say very much yet at the time. But I did open a case against them for the way in which my case is being handled, for the fact that they came on national TV to discuss the merits of a case that was sub judice, which my attorney told me was totally wrong. So I have laid a case against them. Amongst the things that happened is I was recorded by an advocate. I do not recall giving her permission to do it, or maybe I did, but I don't recall it. The advocate comes here and discusses the content of that recording, which in my view is privileged. Not that I have a problem with what she said, but because I want the whole 2-hour recording to be played here, Chief, because you must hear what she said. You must. But like I say, there are certain issues where perhaps you must guide me, Commissioner. As you've learned in our first session, I'm not a lawyer. Perhaps you must guide me.
Okay.
So based on the issues raised before the Commission, I respond as follows. I relied upon the IDAC official responsible for my commissioning process. Any administrative irregularities were outside my control and do not affect the truthfulness of my evidence. I submitted my complaint when requested. Decisions concerning the registration of a docket were made by investigators, not me. My role was limited to reporting information that I believe warranted investigation. Decisions to investigate and arrest relied entirely with the IDAC and its prosecutors. Questions concerning document management or record keeping should be directed to the investigators responsible for maintaining the relevant files. I appeared before the authorities as a complainant because I believed that I possessed information concerning alleged wrongdoing. I provided information truthfully and in good faith. I did not direct the information, decide whether a docket should be opened, determine how affidavits were processed, or decide whether arrest should be made. Any administrative issues concerning the commissioning, filing, or handling of any affidavit should fall within the responsibility of the investigating authority. I stand by the substance of the information I provided and will continue to cooperate with any lawful inquiry. I believe my legal right as a member of parliament, as a citizen, to report information that I believe warranted investigation. Whether to investigate or prosecute was a decision for IDAC and the prosecuting authorities. I had no control when investigators opened a docket. My role ended with providing the information requested from me. Whether my complaint fell within IDAC's legal mandate was for IDAC to determine. I was entitled to submit information. I was not responsible for interpreting the law on behalf of IDAC. I expect investigators to independently verify everything that I report. Their investigative decisions was theirs alone. I supplied information that I believed to be accurate. It was never my role to determine whether sufficient evidence existed for arrest or prosecution. Reporting suspected wrongdoing is not the same as directing arrest. Those decisions were made independently by investigators and prosecutors. Once I provided my statements, responsibility for safeguarding, managing, and presenting those statements rested with IDAC. I humbly request that the Commission should perhaps request the chain of custody of my submitted affidavits from IDAC.
You may proceed, Ms.
Ms.
Ramsamy.
Drushanta Ransamy, IDAC prosecutor. I confirm that Advocate Drushanta Ransamy was a member of the IDAC personnel who I met on 6 January to sign my A1 statements. I wish to respond to comments made by Advocate Ransamy in a testimony, which in my view may have no bearing on the criminal case that I opened with the SAPS. I stated upfront that when I met Advocate Ransamy, she introduced herself to me as an advocate. It was a one-off meeting and I've not seen her since. I now understand from her own testimony before this commission that she is not an advocate. She is in actual fact a lawyer. Now, Chairperson, if she's brave enough to hand that whole recording over, the first words to me are, I'm Advocate Drew Ransamy.
My understanding, though, is that within the NPA, they are given or assigned the proposition of advocate just as a position, not so much whether she is admitted as an advocate or as an attorney. That's my understanding.
Okay, Justice, if that's the answer, then I 100% accept it. Okay, I'm just going to move on from the next point.
I think you must read it into the record.
Must I read it into the record?
Yes, I regard the distinction as important because notwithstanding what the chair said, she did give the same explanation that the chair is giving. And
no problem, Advocate. I just thought the chair was just correcting me because
okay.
I regarded the distinction as important because I was led to believe that she had the title of advocate. Insofar as she took the time to explain her professional status to the Commission, I believe she did not exercise the same degree of circumspection when she interacted with me. I was extremely surprised to hear from her testimony before the Commission that our conversation had been recorded. I do not believe, Chairperson, she requested my permission as the whistleblower and person providing the information to record the conversation. I absolutely do not recall her asking that question. I do remember that there was a cell phone on that table which was untouched for that whole 2 hours, if I think about it. What concerns me further is a recollection of the events of the day which I met with the IDAC staff. I deal below with my response to various statements made by Advocate Ransamy. Now, Chairperson, it's just here that I'm a little bit afraid because this issue is under investigation, but I'm going to try to assist the Commission as far as I can. The issues raised by Advocate Ransamy include 2 different versions of my statements: the authenticity of my S27, the inaccuracy of IDAC's record keeping, the integrity of evidence presented in court and to the Commission, the handling of the interview process, the 2-month delay allegedly involving in opening a case before I came to IDAC, and my possession of the documents. Chairperson, I only gave one account in my interview. Anything that happens after that, Chairperson, that is not my business. Any later differences between documents should be explained by those responsible for preparing and preserving the records. The accuracy and custody of investigation records are matters for IDAC. Once I presented my information, I had no control over how those documents were stored or preserved. I attended the interview in good faith and answered every question from the investigators as honestly as I could. Any inconsistencies in the investigators' documents should be addressed to the investigators and not to me. I opened criminal cases at Grand Central Police Station in Cape Town 2 days after receiving the documents. The case numbers are 1653 of 10, 2024, 1651 of 10, 2024, and 165 of 10, 2024. After not receiving...
Sorry, Mr. Adams, when you say after receiving the documents, which documents are you referring to?
I'm referring to the documents that I picked up in my office that came
On
through.
your office floor? Okay.
After not receiving a satisfactory response from the Western Cape Police, and on the advice of the late General Andre Lincoln, former head of the anti-gang unit, who I regularly consulted on police matters, I proceeded to Johannesburg to open cases concerning the same matters in another province. Now, Chairperson, I just wish to draw your attention to this. Before I go to Joburg, if my dockets are not stolen, I got no business in Joburg. And if I have no business in Joburg, I would never have heard of IDAC. And that to me, Chairperson, is the part that trust me when I tell you, I know you don't miss anything, but I think South Africa is missing. That if those dockets are not stolen, which is what they were, I've got no business with IDAC. I opened criminal cases at 2 police stations, namely Orlando Police Station, under case numbers 4310-2024, 44-10-2024, 45-10-2025, and Langlate Police Station under case number 8711-2024. Upon my return to Cape Town, I reported what I regarded as possible impropriety concerning the handling of my criminal cases and the possibility that the investigations were being compromised or deliberately silenced. I emailed the Minister of Police as reflected in Annexure FAA11, in which I raised my concerns regarding the potential compromise of the investigation. Now, Commissioners, you know, when General Mkhwanazi came to the ad hoc committee, he was the last one to speak. And what he said is, I submitted an email to the Minister at 6:30 in the morning, which is not unusual for me because when I go to Parliament, I'm there before 6. But within an hour, the Minister had responded. I regard that as service delivery. However, the truth of the matter is that I sent the Minister the first email regarding my complaints 10 days earlier. The email the Minister responds to is the second one. And that is also what is not being told. Please say FAA11. The Minister did not wake up before he had breakfast and responded to my email. I had sent an email almost 2 weeks prior saying, Minister, something's happening here. He didn't respond to my email, which is why I initially thought the Minister's part of the cover-up as well. And I apologize to the Minister now. I emailed the Minister of Police as reflected in Annexure FAA11, in which I raised my concerns regarding the potential compromise. I've read that already. The then Minister of Police's office directed my complaint to the IDAC on the same day of the second email. Prior to this, I had not known what the mandate of IDAC was or know any person working at IDAC. Advocate Ramsamy also states under oath that she advised me that I'm in possession of the documents, that me being in possession of the documents was a criminal offense. She has admitted that she recorded the entire conversation of my meeting with IDAC, and because I am confident in my truth, I implore this commission to request that recording and play it before the nation. Many things were said, including a claim from Advocate Ramsamy that she had to flee KZN because of an investigation into SAPS and out of fear of Lieutenant General Khumalo. That, Chairperson, is in the recording. I ask that you subpoena that recording because I've emailed IDAC, I've asked for the recording, they've not responded. We have attempted to obtain the recording made by Advocate Ramsamy to prove the lies she talks about me. The strength of the cases I laid amongst other things. Now, Chairperson, after we've finished with my statements, my A1s, after commissioning it, after having handed the evidence that was given, that I had given to, I think I gave it to Rupeshu because I think Peruma was busy on the phone. I think I may be wrong. Mr. Rupeshu rather. because Mr. Perumal was on the phone, I think. I went down, I went to smoke. I came back up and she says to me, we have enough to move on 2 cases immediately. That will be in the recording as well, Chairperson. So I'm confused when she comes here. Says to you she recorded the meeting, but says to you in the words of Mr. Rapesha that I gave him foko. And I'm offended by that because the meeting went well. She further stated that it was very strange that there were no cameras in the corridor of my parliamentary office that could show who placed the documents under my door, and that she found it highly improbable that this is how I received the documents. I again refer to the Commission. Please, Commissioners, get that recording. I, Chairperson, did not apply for that office that I received. Parliament issued me with a key. The fact that that camera right there does not reach my office as far as I can see, because when I look out the door, I can't see the camera. She asked me, is there a camera above your door? I said, and it's on the recording, it doesn't cover my office. It's on the recording. Why she finds it suspicious, Chairperson, she must take it up with Public Works because I don't install cameras.
But what will the recording help then? Because she said in her evidence before the Commission that she found it highly improbable that there was no camera near your office.
No,
so what is it that you say the recording will reveal?
The recording will prove that I did not give them focal. She was ready to move on 2 cases, her own words. The recording will also prove that she said to me, and when I think about it, I don't know if she was trying to bait me or to get me to say something. I had to flee KZN because of Khumalo. I had to pack up and come to the Western Cape. She says it. It's on the recording.
Yes, I'm asking about paragraph 394, where you say, she stated that it was very strange that there were no cameras in the corridor of my parliamentary office that should show who placed the documents under my door, and that she found it highly improbable that this was how I received the documents. She said that in her evidence before the Commission.
Yeah.
You say, so why do you say, I will again refer the Commission to the recording that must be played? How will the recording help us?
I want the committee to hear my response to her when she asked about the cameras and her response back to me.
Okay.
I want the committee to hear that.
That you said there are no cameras, and what did she say?
She said, no, that's fine.
Okay.
Or something like that. I respectfully request that the Commission have the recording transcribed and placed on the record. The purpose would be to enable the Commission to identify what I believe are material inconsistencies in Advocate Ransamy's evidence concerning the events that took place on 6 April 2025. Due to a current case I have opened concerning alleged impropriety by IDAC and its officials, I respectfully decline to respond further on certain aspects in order to avoid jeopardizing the criminal case. I am able to provide a video to the Commission which in my view demonstrates that Advocate Ransamy's allegations regarding the probability of how I received the documents created an unnecessary and misleading impression. I take great offense at what I regard as a misleading narrative concerning the day at which we met. I respectfully request that the Commission consider whether evidence warrants any appropriate finding or sanction. Advocate, may I please approach you?
Yes.
Can I come to you?
No, perhaps let's take the lunch adjournment, and
Yes.
during the adjournment you may then...
Chairperson, if
yes,
I may?
yes.
Because the colored community will tease you about anything. It's time for me to take my meds, man. So I was just going to ask her if I can just stand outside the door and take my tablet. That's all I was going to ask her. Thank you, Chairperson. We can do it during lunch.
Thank you.
Okay, thank you, Chair.
What time are we back?
Let's adjourn and resume at 2 p.m.
Thank you, Chair.